Good day, everyone. So for me now to introduce the speaker for the session, our speaker for today's session will be none other than Ahmore Burger-Smidt. So Ahmore is a director at Worksman's Advisory Services. She heads up the Data Protection and Privacy Practice Group. She extensively advises local and international clients on all aspects of regulatory compliance, but focusing more so on competition and data privacy aspects. Ahmore advises clients right through Africa, especially around the regional economic blocks of Africa, such as the Common Market for Eastern Southern Africa, the Economic and Monetary Community of Central Africa, as well as the West African Economic and Monetary Union. She regularly undertakes compliance audits, oversees the implementation of compliance programs, and is the principal driver at Worksman's risk assessment and e-learning tools. She also is the co-leader for the Worksman's Dawn Raid team. So Ahmore is a regular convener. She's a speaker. She participates at local and international conferences, seminars, talking around aspects of competition law and data privacy. She is a member of the International Association of Data Privacy Professionals and is currently reading towards her LLD in data protection. Through the partnership between LexisNexis and Worksman, Ahmore has co-authored the LexisNexis published textbook, which is a commentary on the Protection of Personal Information Act. So over to yourself, Ahmore.
Thank you very much, Kabisa. I appreciate it. This is indeed an exciting time that we've now entered in South Africa, where we are squarely confronted with POPIA and the implications that we need to try and interpret in how we will deal with it in South Africa. So if we could just paint a picture, first of all, what today's discussion will be about. The reality is, in collaboration with LexisNexis, we decided not to have a general compliance discussion and discuss the general principles and the 8 conditions of data privacy. I think, and I would like to suggest that this has been discussed over and over for a number of years already. So what we want to do is to address, through the series that LexisNexis will be presenting, core issues for debate and unpacking and understanding and drilling down to actually focus on what it means practically if we have to implement it. And yes, it is going to be a legal discussion. It is law, and we need to take that into consideration. The reality is, where we are today, we know that POPIA impacts all businesses, whether it's small, whether it's large. We do not have an exemption or a carve-out in South Africa in relation to small businesses. It impacts on natural persons, individuals, data subjects, living people, but it also impacts on juristic persons, and we have to understand that, and that happens to be one of the core themes that keep on repeating, and we therefore decided that we will address it today in the discussion. And that what links directly to that issue is the information and personal information that might be in the public domain. How should we interpret it? What does it mean in terms of POPIA? And we decided that those 2 issues should be addressed for purposes of today. But before we carry on, let's just set the record straight, because I think it is important for a couple of misconceptions to be addressed and understood, and where we are now. So this was indeed an element of surprise. I think the one good aspect coming out of COVID-19 is that we've had a lot of debate around the tracking and tracing apps and how government need to rely on tracking and tracing to actually fight the COVID pandemic. We had Judge O'Regan appointed to monitor how personal information will be dealt with in this time. At the same time, the Justice Portfolio Committee in Parliament stood up and said, but it is a travesty that we do not have a robust, fully enacted, promulgated piece of legislation affording individuals the protection of their personal information. And this perfect storm resulted into our element of surprise, the announcement that indeed POPIA is now fully enacted, and we've got 12 months within which to comply with POPIA. But if we look at this, we need to understand there's always a legal basis for any piece of legislation. In this instance, the Constitution in Section 14, that affords individuals the right to privacy. But more important, and I think it informs the debate around juristic persons, Section 8 speaks to the privacy of juristic persons. So it's not something unique that we've pulled out of the air in South Africa. It goes to the foundation of who we are as a country in our Constitution. And if we look at Section 14, it provides every single individual the right to privacy, not to be searched, not for property to be seized, not for communication to be tracked and listened in onto, which gives us the outcome of this, the effect that POPIA protects our guaranteed right to privacy in the Constitution. And this is indeed a day to celebrate for us as South Africans. The reality is we need to know that POPIA is not aimed at stifling business, at stifling the flow of information, at making it more difficult for us as an economy to function. But in fact, POPIA's at the core of POPIA lies the enablement of economic activity, while at the same time it provides for responsibilities and duties and rights. That is the overall environment that POPIA paints. And if we consider all of this, we need to realize that there are certain myths around POPIA and address these. And for me, this sets the scene as to how we will deal with the implementation of POPIA going forward, and how we will take on board in terms of processes, in terms of know-how, in terms of debate, what are the true landscape we are confronted with. And on the screen that you can see now, we have painted 9 myths around POPIA. The reality that we know is that POPIA does not only impact business. I said that right at the beginning. There are no exemptions like in Europe for smaller businesses. So if we look at implementing POPIA compliance within a company, whether it's big or small, it will have to be implemented. But this also means that this is not a cookie cutter approach. We need to internalize the provisions of POPIA wherever we find ourselves in the organizational structure we are. Also, if there's a myth that says we've got plenty of time to do this, because we know now we've got 12 months ahead of us, well, almost only 11 left. What we are confronted with is that we do not have a lot of time. To unpack and understand the implications of POPIA takes time, and that is just the reality that we need to accept. We consider myth 3 is that one of the things that people often say is, but we only have to worry about customer records. That is not true. You do not only have customer records, you will be held liable as a responsibility for your suppliers, those third-party entities to which you outsource responsibilities and duties and functions. Throughout the value chain, there are linkages with POPIA, and therefore it's not only customers that you need to be concerned about. This also includes juristic persons. The 4th myth is that we don't have a marketing database. So if we look at marketing issues, POPIA does not apply. All companies, all legal entities need to market their products. That means somewhere within an organization, there's a tool or a database or a methodology in terms of which customers are approached. Because if we don't have customers, we can't sell our services and our products. But those customers do have personal information. So the fact that you do not have a marketing database does not exclude you from POPIA, and that doesn't mean that you can just draw a little cross behind POPIA and say, we don't have to concern ourselves with this new piece of legislation that's been enacted. Myth 5. POPIA only covers IT records. It's this fourth industrial revolution tech world we live in, and therefore it's all IT related, and we needn't consider anything else. No, that is not the reality. Whether it's hard copy documents or electronic documents, POPIA applies to both all information and data we've got as far as it relates to natural individuals and juristic persons. So it is not only IT records, that is, and electronic records that will be relevant. Myth 6, we don't control the data. We just process it, so we don't have to worry. We're one of those down the supply chain, down the value chain service providers. So we don't decide how it's obtained, what will be done with it, how it should be processed, and therefore let's not concern ourselves with that. That is an absolute myth. You will be responsible for the way you treat and process personal information, how you keep it secure. Up until the day you delete it and you don't need it. So don't think because you're just a third-party service provider that POPIA does not apply to you. Myth 7. This is all about data. The IT department can handle it. You know, this takes us to this whole issue of where people often ask, but who should be responsible for compliance with POPIA? And in a lot of instances, people want to park it off in the IT department. That is not the reality. The reality is that POPIA and the impact of personal information, how it's obtained, how it's used, how it's passed on, what we do with it and how we use it, requires that we undergo a cultural change. We need to think about POPIA compliance against the backdrop of a cross-functional skills requirement. It's not only IT, it's not only HR, it's not only legal. It is indeed a cross-functional team that should come together and take responsibility for internalizing and unpacking and implementing POPI within any company. Myth 8. Data about children is no different. We can just carry on. When it comes to children, we do not have to categorize the information. It centers also around special personal information. This is an absolute myth. There are specific provisions if we deal with the data of children. For instance, consent, which is a fundamental pillar that we need to adhere to. So if you are considering and if you're dealing with the information, personal information of children, make a note. There are special conditions that you will have to comply with. And then the last myth, we've got a tick box for approach. On our website, there's a tick box. So we've got consent and we needn't concern ourselves with it. That is an absolute myth and very far removed from reality. Specific consent provisions must be in place the way we obtain consent. But not only that, if we don't have consent, how can we justify the fact that we are processing personal information? These are very important aspects, and specifically if we consider consent and legitimate interest and aspects surrounding this, we will be in future addressing these aspects because we do believe it's important to unpack it. It also, if we set the landscape, introduces the concept of confidential information and personal information, and this arm wrestle, whether is it confidential, does it mean it's personal information? If it's personal information, does it mean it's confidential information? Just remind yourself that confidential information can go far further than personal information. Can be personal information captured as part of confidential information, but not necessarily. So we need to be clear and understand the concepts clear in terms of how we internalize POPIA within our companies. On the screen reflected in front of you, we've detailed the concept of it's not personal information. If it's not personal information, remember POPIA is not relevant for that information and the way you process it. But two other categories, personal data or personal information as such, where you can identify a living individual, here you need to focus because POPIA applies to every single aspect here. and also then sensitive and special personal information. It is important because there are special requirements around this, as any organization do have information around the race or the ethnic origin of their employees. If we look at health information, all of that constitutes special information that we need to focus on in terms of POPIA compliance. I included in terms of sensitive personal information a concept, and you'll see it in the middle of that column, genetics. Now, genetics is part and parcel of the GDPR if we consider special personal information. However, the South African definition does not refer to genetics. It's my submission that this is one of the first aspects that we ought to address if we review the legislation in time to come, that the definition of personal information and sensitive personal information, special personal information, should be elaborated. But that's just a thought, something to think about as we go along. Now, I said we're going to discuss, once we've gotten rid of all the myths around data privacy, two core aspects. The concept of natural persons versus juristic persons, and how did we get to the point as a country that we actually decided that our data privacy legislation will also apply to juristic persons, and then we'll move over to the concept of when information is in fact in the public domain. Now, if we consider juristic persons and the fact that South African as a jurisdiction decided to go against the rest of the world almost in totality, in terms of including juristic persons, and that the POPIA legislation will apply to juristic persons, it might feel initially as a weird concept. Why did we do this? Why did we actually decide to go down this road to consider it? And we have to go back to the courts and see what did the courts say? How did we reach this point? Now, I said earlier, Section 8 of the Constitution allows for a right to privacy also to be afforded to juristic persons. If we look at the case law going back a number of years, Financial Mail versus Sage, in that matter, the court clearly stipulated that there is a right to privacy to be afforded to juristic persons. And one of the bases on which they declared this and came to the conclusion is based on the fact that companies do have a reputation, and they do have a reputation that can be infringed upon. And therefore, even though a company doesn't have a dignitas like you and I do, they do have a reputation, and that therefore affords them a right to privacy to protect the information that they hold in order to protect their reputation. If we look at motor industry fund administrators, where the debate centered around the theft of confidential oral and written communication by the directors and the employees of the company, it was clearly stated by the court that this is an infringement on the privacy of the company, that they own a right to privacy of their communication that is confidential that they hold. And then, for me, an important matter to consider and always have at the back of our minds is the Hyundai matter. We heard in the 2000s where the court said, but just remember one thing, a juristic person is indeed protected and have a right to privacy. But there's a level of justification, almost a balancing that has to take place in terms of the specific circumstances of each case, to what extent that privacy will be afforded. And if we move along, POPIA provides in Section 5 for the rights and for rights in terms of the processing of personal information. Now, if we try to mirror that against where a juristic person or legal entity finds themselves, it's very clear to see how POPIA actually applies to legal entities, because a legal entity do have the right to be notified when information is collected about the legal entity. I want to interrupt myself here and say the following. The debate between natural individuals, people, and legal entities, and the right of privacy being afforded to both, can often be a confusing concept. And we've seen that internationally as well. In Europe, there's massive debate around whether a right to privacy should be afforded to a legal entity. There are commentators that agree with it and insist that it ought to be afforded to legal entities. And then there are commentators that says, but it can never, ever, ever happen. It is illogical for that to actually be afforded the right to privacy to legal entities. Now, if we consider this big debate, it is informative to realize, take for instance, a sole proprietor. That individual, that one man, one woman standing there has the right for his or her personal information to be protected. But you can never separate that individual from the legal entity, which inevitably means you have to afford that legal entity also the right to protection in terms of the privacy legislation. And if we look at data privacy legislation, the collection of information, the right to be notified that information is collected, surely that ought to be a right that the legal entity has. Also, the reality is that they ought to be afforded the right to be notified if their personal information has been accessed or acquired illegally. Think about a data breach. We cannot exclude that right or take away that right afforded to a legal entity in terms of POPIA. Also, whether you actually hold other legal entities, the B2B space, hold information about the company and what information is being held, for that information to be corrected when it is incorrectly reflected or outdated, or just object to the processing of the company's personal information because there's no need for it to be processed. These are all fundamental core values that ought to be recognized and afforded to legal entities to complain to the regulator if indeed something goes wrong and their information is processed not in a lawful manner. And then a big issue that we are going to consider in years and years to come is the ability to institute claims for civil damages and the impact that will have on how we internalize, understand, and practice data privacy legislation in South Africa. So let's just think practically, if we consider what this actually means, you know, what information of a legal entity require protection? The what is it? What is this thing we're dealing with? Now, the South African Law Reform Commission, while they were drafting POPIA and debating POPIA and answering questions and public debate around the POPIA legislation, identified certain areas where they said clearly these areas, this information of juristic persons require protection and it's necessary to protect the information. And there are therefore areas of focus and specific information that ought to be highlighted for people to be able to implement the legislation. If we look at the specific areas, the various areas where the protection of personal information of juristic persons are clearly important, the South African Law Reform Commission highlighted issues around business information when we consider credit referencing, credit bureaus. That information of businesses ought to be protected. They specifically spoke about the telco sector and the information of subscribers, of communication subscribers and the users ought to be protected in terms of affording the ability for juristic persons to stand up and say, but I want my information to be protected and covered in terms of POPIA. And then another interesting concept, the debate around business information being provided to the state institutions for statistical purposes. I'm leaving and I'm not touching now on de-identification of information and research purposes, but the core concept that the Law Reform Commission highlighted was that businesses can stand up and say, but we insist and we entitled and we are protected in terms of privacy legislation for our information to be protected. Specific kinds of information, financial information of a juristic person. And this is why whether information is in the public domain will become very important. Because if you're not a listed entity, your financial information is not in the public domain. However, if you're a listed entity, another set of rules will apply. Corporate strategies, number of employees, terms and conditions of employees, financial remuneration. These are all specific sets of information that constitutes personal information of juristic persons. And that brings us to the concept of what if this information is then in the public domain? How do we deal with it? How do we interpret it? Because what we do know is that POPIA is not very explicit in addressing the issue of information in the public domain. It deals with public domain information to a limited degree, in that it defines for us what is a public record, and then it also states when is it that POPIA will not apply to a public record or the public domain. So this leaves us in a situation where we actually have to try and interpret and apply POPIA to what we do on a daily basis. And if we consider what it is defined as a public record, it means a record accessible in the public domain under control of a public body, whether or not it was created by the public body. So I can access a record held by a public body that is in the public domain. And that gives a totally new view on how we should actually go about in terms of interpreting and applying POPIA. So what does the Act explicitly state? And it's far easier to actually start at this point. Explicitly, the legislation says, if the personal information forms part of a public record, or it's been made public by the data subject, there's no obligation to collect it directly from the data subject. Also, if the information, again, is derived from a public record or has been deliberately made available by a data subject, then there's no reason, if I want to further process this information, to look back and think, but what was the original reason and the ambit within which I actually acquired and collected the personal information? And only if it's compatible with that original reason or objective why I collected the personal information, only in those cases can I then engage in further processing. No, the legislation is clear. If it's in the public domain and derived from a public record, or the data subject has made it available him or herself, you do not have to comply with the provisions in terms of POPIA in relation to further processing. Also, if we consider special personal information and the information of children, the legislation is explicit that in those instances, if it's in the public domain, I've made it public, I've released the information myself as a data subject, or it is a public record that's available, the provisions of POPIA does not apply to that information. And again, let's just have a look at what the courts have said, a look back in terms of this information in the public domain. Because if the legislation is not clear on this point, we have to look at jurisprudence and how that will inform us to understand how we can go about with information in the public domain going forward. To an extent, POPIA gives us certain carve-outs where we know we can deal with personal information, but we also need to consider what the guidance we have received to date from the courts. And informing this concept is the principle of the reasonable expectation of privacy. What is the reasonable expectation of privacy of a data subject if information is indeed in the public domain? And before we look at the cases, there is a matter of late before the Japanese competition regulator, and it dealt with, it's an app that they developed, Do No Evil is the name of the app. And the Japanese information regulator actually said, but this app that collects information from various sources about juristic persons and publicly available information is against and contrary to the Japanese data privacy legislation. There's a lot of criticism around that. And core to this criticism against the judgment by the Japanese competition regulator is the fact that if you, as a data subject, deliberately make your information available in the public domain, can you then turn around and claim protection of that personal information? And therefore, the criticism is that there is and cannot be a reasonable expectation of privacy if you yourself as the data subject make the information available. And that is to a large extent, or actually 100% in line with Bernstein versus Bester. And the court ruled in Bernstein versus Bester and say, yes, indeed, you've got a big world of privacy and you can stand up and claim your privacy. And you should acknowledge it as long, and it ought to be respected as long as it is in your personal sphere. But once you have actually released that information to form part of the public set of information and social interaction, your personal space gets smaller. You can't then claim protection of all your rights and all your data if you have released it. And the same theme repeats in the Dental Council matter that was heard before the Constitutional Court in 1998, where it clearly says that we need to consider where the public space starts and ends versus privacy, and how that can be, how privacy can remotely be impacted on if indeed personal information is in the public space. Chabalala versus Matsimang and others, where the court said, but there's a public interest also in commenting on issues and information in the public sphere. However, what is important for me to highlight when we discuss what the courts have said, and that your personal space shrinks once information is in the public domain, and your expectation, your reasonable expectation of privacy, is the fact to note that if we look at sensitive, special personal information, we can't say that even though it is in the public domain, it's not private anymore, because there are certain public fact or private facts that will always and still retain its private character, such as medical information, health information. So when we indicated at the start of this seminar and discussion this morning that we do realize that there are specific sectors that needs unpacking and debating. The healthcare sector is definitely one of those sectors that we should be focusing on very closely going forward. So where does this leave us? Based on the POPIA and the jurisprudence, we can conclude that a high level of protection, data privacy protection, will be afforded to information in the intimate personal sphere of life. However, the courts have clearly indicated that a far lower level of protection to personal information will be given once it forms part of the public sphere. Now, this is where we will move to a future that's going to be very interesting in applying data privacy legislation to this information in the public sphere. Because the answer is not a clear yes or a clear no. Sometimes POPIA will apply and sometimes POPIA will not apply. And how do you balance and how do you interpret it? And therefore, even though you can go about with information in the public domain, in some instances freely, in other instances you need to sit and focus around what the obligations, the conditions of processing are, and whether you are in fact allowed to freely deal with the information at your disposal. So let's look forward. It's been a very, very long way to get to where we are today. 2013, when this act was adopted by Parliament, I did my first POPI assignment in 2009, and I worked in Germany, and I thought it was intriguing, data privacy legislation and how it's practiced there. Delighted in 2013 when we had a piece of legislation, and it took us till this year with COVID-19 to actually reach the point where we have now fully enacted legislation. We've got 12 months to comply. We can't go back. We need to move forward. You need to consider how will you comply within the 11 and a half months left. So if we unpack it and if we try and internalize it and if we debate these issues, it is clear that there are concepts that can be confusing, and we need to try and understand and engage with one another to apply it to every and single company and legal entity. Right size it to the needs and the requirements of the specific company. We need to look inward to understand what POPI actually means in what and the way we do business. And we also need to look outward to understand the obligations that we might be confronted with. At the end of the day, we need to contribute to the debate, and we need to change the culture in South Africa, because POPI is not going to go away. We are not going to turn back on this road. We can claim privacy in South Africa. It's going to enable and empower the economy. It's going to make engagement in terms of the global economy easier for us. It's going to contribute to economic growth. We need to implement it to actually retain our legal entity's reputation, retain the confidence and the trust of customers, and in that way consider how will we make POPI and use it as an asset, and the data we've got, reap the benefit out of that on a day-to-day basis. I thank you for the opportunity.
Thank you, Ahmore. Thank you for that. I must say I enjoyed the Mythbusters. I think being an HR professional, some of them were quite key for me. So I see we've got a number of questions that have come through. So I'll just choose two for now, because I am cognizant that we have another speaker lined up. The first question that has come through is that public domain versus POPIA versus the Promotion of Access to Information Act versus POPIA. How are these?
Yeah, so this is a very interesting concept, because we've now got one regulator dealing with both pieces of legislation. If you visit the Information Regulator's website, which you ought to do, it's an interesting website and it's starting to grow, you'll see there's an executive overseeing POPI and there's an executive overseeing POPIA. And POPIA specifically provides in section 114 that the information officer that is provided for in terms of POPIA, that person will have to put in place and amend the POPIA manual. So in a sense, we've got two pieces or the obligations of these two pieces of legislation being merged by POPIA and under the banner and the flag of the Office of the Information Regulator. So POPIA is not going to go away. The obligations are not less. In fact, we need to link it. However, we need to be aware of the fact that there are certain misalignments between the two pieces of legislation. The definition of personal information and POPIA being one. And again, these are things that we need to consider and raise and debate with the information regulator going forward.
All right, I was going to ask you question number 2, but I think you kind of led through it swiftly. So maybe can you introduce our next speaker?
Wonderful. It is an absolute pleasure for me to introduce to you Colin Vipont. He is a full-time member of the Information Regulator, and in my view, actually the right and left hand of Advocate Klakula, and we appreciate that he made himself available to address us this morning. Colin is indeed a lawyer by training and by practice. He is an exceptionally skilled individual across various areas of the law. And if we consider data privacy from technology risk management, information technology risk management perspective, straight through to cybersecurity, because these are all things that are important and that we need to keep on our radar. He's got the experience and the track record to be a full-time member of the information regulator and guide us going forward. I appreciate the fact that Colin stepped out of another meeting to join us today, and we look forward to his address. Thank you, Colin.
Good morning, Ahmore, and good morning to all the attendees. I would like to focus my brief presentation, if I can call it that, on the progress made by the information regulator to establish its administration and operationalization of the Protection of Personal Information Act, as well as POPIA. So I'm going to start with the office. We currently have a limited capacity in our office. Our office in the main consists of the CEO, who is the head of the administration, and then you find 5 executives who currently supports the CEO. Those executives are the CFO, Chief Financial Officer, the executive for corporate services, the executive officer for legal policy research and information technology analysis. And then you also find the executive for POPIA and the executive for POPIA, as Ahmore has referred to in her presentation. What is very important to appreciate is that we still have to recruit one more executive, and that executive will be responsible for education and awareness, because that is a statutory requirement in terms of Section 40 of the Protection of Personal Information Act. So further down, we have managed to recruit personal assistants, about 5 to 6, allocated to different members and the CEO and the executives on a sharing and rotational basis because of financial constraints. We've also managed to, in the meantime, advertised for certain positions, and those positions are, I think, accessible on our website. And due to COVID-19, we experienced some delays. So that's where our office currently stands with regards to the establishment of our administration. So colleagues, what is very important now for me is to move into the more legal side of things. So the first question that we need to ask ourselves is, where do we stand with the effectiveness or the operationalization of POPIA, the Protection of Personal Information Act? Colleagues, what happened on the 1st of July, as Ahmore referred to it, was actually the announcement of the effective date and the coming into effect of POPIA. POPIA is currently effective, operative, and in use, except for Section 110 and Section 1144. Those 2 sections will become operative, and those 2 sections will become in force on the 30th of June 2021, as announced and proclaimed by the President of the Republic of South Africa. What is very important to understand is that subordinate legislation, which is our regulations, have not been declared operative, in force, and in use. The regulator is currently considering a specific date to announce the effectiveness of the regulations as it stands. What is also very important to understand and appreciate is the fact that the regulator has considered the guidelines on the registration of, on the drafting of codes of conduct. So these guidelines have attracted a material number of submissions, and those submissions are currently being considered by the information regulator, and the information regulator is in the process of finalizing the guidelines on the registration of, the guidelines on the drafting of codes of conduct. So as soon as we have finalized the draft, as soon as we've considered all the submissions and we have finalized our own interpretations, we will then be able to release the final guidelines on the drafting of codes of conduct. What is also very important to appreciate is on Friday, being the 17th of July, the information regulator has released what we call the guidelines on the draft, the guidelines on the registration of information officers. Those guidelines have been made available on our website and have been forwarded to our strategic partners, and we'll continue to forward them directly to our strategic and partners and stakeholders. What is also very important to appreciate is during COVID-19, the information regulator has released a guidance note that directs what we would call the manner in which COVID-19 should be managed by the government and responsible parties, as well as individuals who are affected by COVID-19. So for all intents and purposes, the information regulator as it currently stands is monitoring the whole environment concerning COVID-19 and government's interventions and the management of the spread of COVID-19. Key to everything that we do is also our engagement that we had with the judge, Justice Kate O'Regan, who was appointed as the special judge for COVID-19. So that in itself was a milestone, and there was a very strong direction and a basis for the information regulator and the office, as well as the Justice Kate O'Regan, to engage and interact. Even though the mandate of Justice Kate O'Regan as the COVID-19 judge is limited and very small and confined, the regulator has seen the need because of our broad mandate to have such constructive engagements. The regulator as it stands is also considering numerous other requests from various parties concerning, for instance, complaints about misuse and abuse of their data by responsible parties, complaints regarding issues, complex issues that resides in the telecommunication industry and the health industry. And what is also very important for us to appreciate at this very moment is the fact that the regulator has drafted what we would call its office programs to continue to do the work and perform the work as undertaken in its annual performance plan, even though most of the work will happen remotely, or the strategic work, because of the fact that we are beginning to reach a spike in the spread of the virus. So our office still remains accessible, and our office still remains open for engagements and communication and interaction. And lastly, it is also very important to note that the information regulator has this 1 year grace period. There is a 1 year grace period which is automatic for responsible parties to comply with the provisions of POPIA. But what is also very important to appreciate is that the information regulator will continue to monitor the environment on a high level to see and understand if the minimum requirements have been met by responsible parties to comply with the provisions of the Protection of the Personal Information Act. But what is key to all of this is the fact that responsible parties, if they have not done so, need to undertake what we call a privacy impact assessment. And that specific assessment will guide responsible parties in terms of how they identify their business requirements that needs to be aligned with POPIA. For instance, data kept in HR. And we all know, for instance, HR in most instances becomes an internal and a support function for most companies. It's not the core, but HR in itself holds very critical data ranging from personal information as well as special personal information. And what is also very key to understand among all of this is the fact that we need to adopt a progressive approach to the regulating the environment, the privacy environment in South Africa, so that all responsible parties can understand and see that the information regulator is both serving a support function as well as a regulatory function. For the purpose of this engagement, I'm going to stop at that. Thank you so much for the opportunity. Thank you.
So thank you, Colin. But you can't run away that quick. We are having massive questions that are coming through. So maybe I'll just ask you one question for now. And I think for the audience, I mean, there's quite a number of questions. I don't think we'll answer all of them in this session, but I think the question for you, Colin, goes along this way. I work in the NGO domain, and my question relates to this sector and applying POPIA to our services, as well as how POPIA is being implemented in the government sector. As oh, now the question has gone away because more questions are coming through. This, give me a second there. Let's find it again. Let me finish it for you. Okay, so it says, I work in the NGO domain, and my question relates to this sector and applying POPIA to our services, as well as how POPIA is being implemented in the government sector, as much of our work is linked to the Department of Justice and Social Development.
Thank you. Is that the full question?
That's the full question. I think an assessment of how POPIA work in those type of industries or sectors.
Thank you so much. Just a brief answer or response. Ahmore referred to the compliance obligation of responsible parties, and in terms of POPIA, responsible parties have a duty, be it an NGO, be it a private company, be it a CBO, community-based organization. All of these institutions, organizations need to comply with the provisions of the Protection of Personal Information Act, as well as the Promotion of Access to Information Act. And it's very critical and important for NGOs to also understand their business in view of the requirements of the Protection of Personal Information Act. If they do so, it will then make it easy for them to understand what are their compliance-related obligations that they need to fulfill in terms of the Protection of Personal Information Act. Thank you.
All right, thank you very much. I think we just have 2 minutes and then we close. Ahmore, final remarks in 1 minute.
Thank you. I think in the first instance, Colin, thank you very much. We appreciate the opportunity to engage with you and the Office of the Information Regulator and Advocate Klakula, and that you always step forward to engage with our clients and on the issues in terms of the legislation. It is indeed a pleasure to work with you and then form a strategic relationship with you and how we're going to grow this practice and the application of POPIA going forward. We greatly appreciate your time. And then just for the audience, we hope that today contributed to an extent to the unpacking and internalizing of POPIA and how you ought to be thinking about POPIA and the impact on your business and your engagements in general, how to live and breathe the legislation, internalize the concept, and ask the questions that are difficult and sometimes easy, but still you need to understand the way forward. From a Worksman's perspective, we thank you for attending. We regularly write on issues around data privacy, and you're welcome to visit our website and sign up for the newsletters that deal with these concepts. And a last word from me on POPIA specifically is just to say, sometimes it will be easy, the road to compliance and unpacking and internalizing and applying POPIA, and sometimes it's going to be very difficult. You have to apply POPIA to right-size it for your specific company. And then lastly, to LexisNexis, from Worksman's, we appreciate the relationship and the collaboration between Worksman's and LexisNexis. We thank LexisNexis for the initiative and the energy and the organization that went into this. And we will be hosting similar seminars, one in July and one in September. Thank you.